Anyone having business before the Justice of the Superior Court of Justice, Tianani shall be heard. Long live the King, the Honorable Justice. Party, you may be seated.
Good morning.
Good morning, Justice Hennessy. We left off the last day, just about to get to slide 155 of the slide deck, which is exhibit. What was it again? 79, was it? Oh, I'm sorry. Yeah, it hasn't been marked as a number yet. Everyone has it though, I believe. Just to situate us, Professor Messamore, we left off talking about the Section 142 arbitration. And I think before jumping back into the slides, we'll just go through a brief recap of where we left off. If you can remind us about what was the purpose of that Section 142 arbitration?
Right. The purpose of the Section 142 arbitration was to allocate between Quebec and Ontario the proportion of excess debt. And by excess debt, I mean debt that exceeded the debt allowance of 62.5 million. So they had been, of course, one entity as the province of Canada. Confederation would break them apart into two provinces, and each would have to take responsibility for some proportion of that excess debt that exceeded their debt allowance.
Thank you. And what was the result of that arbitration?
In broad terms, the result was an allocation of 53% roughly to Ontario of the excess debt and 47% to Quebec.
Okay.
I can give you the exact proportion if you like, but that's roughly what's.
I think that's fine.
Yeah.
The exact proportion is on slide 148.
Okay.
But I actually wanted to take you back to slide 146.
Mhm.
This is where you had told us about the judgment. And maybe if you could, let's go back to 146 and you can explain for us the principle or the basis on which the arbitrators came up with this split.
Yes, there were a number of principles proposed for how it might be done, but the two remaining arbitrators, McPherson and Gray, after Day resigned, articulated the principle that I'll read that here, that the division and adjustment shall be based upon the origin of the several items of the debts incurred by the creation of the assets mentioned in the fourth schedule of the BNA Act, and shall be apportioned and borne separately by Ontario and Quebec, as the same may be adjudged to have been originated for the local benefit of either, where both provinces enjoyed common benefit, the debt would be divided equally. So I guess local benefit would be how I would boil down that principle. I should say that this wasn't an exact matter of calculation, that there was a degree of imprecision about the accounting surrounding the division of debt. There was some discussion about whether they should consider whether the debt was tied to a particular asset. And that was found to be problematic because the debt might have been paid down at a different rate, or something, debt might have been incurred for a purpose that would leave no asset behind. There were a number of reasons why they don't precisely explain what principle.
Who's they?
I'm sorry, Gray and McPherson don't precisely explain when they came to that ultimate 53-47 proportion, what hard calculation went into that. I think that in the Gwyneth Jones report, she would essentially concur with me on this, that there was a degree of imprecision in that calculation. It was an imperfect sort of process. I would, if we want to think about why that might be so, and thinking about assets and liabilities, I would use the example perhaps of saying somebody who had a home equity line of credit and borrowed money from that to buy a car. That debt might be in a literal sense tied to their mortgage debt, but that would be in a sense a kind of distortion. So I only mention that analogy because it shows that there was a degree of imprecision about it, but about the process. But the ultimate result was that they determined a 53-47 split.
So the last time we were here, we talked about this idea that the debt should, that the province that reaped or enjoyed the benefit of an asset should bear the associated debt. And how does that principle relate to this local benefit principle, if at all?
Well, I guess that that debt was allocated based roughly on this local benefit principle, that if it says if the debt originated with something that was for the local benefit of either Quebec or Ontario.
Thank
Use
you.
the word local
Well,
for that entity we're talking about, Ontario or Quebec.
correct. Yeah. So it's actually the term used by the arbitrators, local benefit. So yes, that's what I infer they meant by that.
Thank you. So can you remind us then how the Robinson Treaty annuities fit into this section 142 arbitration? Why is this relevant for the Robinson annuities?
Yeah, so among the debts that would have to be considered were indeed all the annuities, including the Robinson treaties. I should make it a distinction here. Actually, I used the term distinction in my testimony last time, and I want to be clear about what I meant by that. That I said that Ontario's council, Cameron, I believe his name was, referred to the Robinson treaties and drew a distinction. What I want to make clear is that nobody at this point was making a distinction in terms of the Robinson treaties being tied to a share of resource revenues. Nobody thought in those terms. They were just treated as other annuities, other Indian annuities were treated. So the distinction in question was that
Distinction.
I'm sorry, in annuities,
Distinction
that were
between what?
between the Robinson treaties and other Robinson treaty annuities and other annuities was more with respect to timing. And so what I mean by that is that at the time of this arbitration in 1870, the Section 142 arbitration, some annuities were being paid with respect to treaties that had been concluded before the creation of the province of Canada, so before 1841. They were often called the old annuities. I think Gwyneth Jones in her report calls those the civil list annuities. And I kind of like that phrase because that's a good way to think of them. They were provided for permanently in the civil list. And to my recollection, the amount was $26,664 for what that's worth.
Can I just interrupt there as well? And now are we talking about the civil list after the Act of Union? It was like the, do we need to go back to that slide, I wonder?
Yes, sorry, that would have been, they would have been provided for in the civil list as of 1846.
Okay.
Yeah.
I think that's fine, thanks.
Yeah. So in addition to these so-called old annuities or civil list annuities, there were annuities that were being paid with pursuant to the Robinson treaties, $4,400. $4,400 annually. And there were also annuities being paid with respect to Lower Canada. And in the case of Lower Canada, I think I said last time, those weren't for a particular treaty. Those flowed from legislation in 1851. So those two amounts that dated from after that 1846 civil list were also annuities that had to be paid, 4,400 and 4,000, altogether making 35,000 plus. And so Cameron for Ontario at the time of the Section 142 arbitration made a distinction with respect to timing for when those annuities had been, when that obligation had been incurred.
And Cameron was the counsel for Ontario.
Yes, yeah. So all of these annuities together, the old civil list annuities and these new two separate annuities, Robinson and Lower Canada, had to be provided for in allocating debt under Section 142 in this arbitration.
Thank you. And
I guess my point being that what I mentioned last time is that Cameron suggested that because the amount for the Robinson Treaty annuities and the amount for the Lower Canadian annuities were roughly equivalent, he rejected Quebec's argument that those annuities should be treated as a Section 109 trust and said, since they're roughly equivalent, we can offset one against the other and treat them both as debt in the
treat them both as debt of
the province of Canada. Yeah, to be split according to the 53-47 allocation.
Let me see if I get that.
Okay.
I'm not sure what was being proposed by Quebec, but you're saying Cameron, as counsel for Ontario,
Correct.
noted
Yeah.
that the amount of annuities under the Robinson treaties, and the amount of annuities under the Lower Canada Treaty were very close.
Yeah, I should
s-
specify though, Lower Canada was not pursuant to a treaty. It was pursuant to legislation passed in 1851. But yes, so
Did
far,
it create annuities?
yes, it did.
Got it. So the Lower Canada project annuities
Okay,
were similar in an amount to the Robinson treaties annuities.
correct.
So Cameron, counsel for Ontario, proposed that they offset one another, or that, sorry, didn't propose, noted
Mhm.
they pretty much offset one another. So
Yes.
proposed they be treated as a debt of the province of Ontario and then subject to the purport, or the province of Canada. And which would mean they would have applied to them this proportional split.
That's correct.
And the
Yes.
alternative was what?
The alternative proposed by Quebec was that these annuities should be treated as
these
a
annuities.
I'm sorry,
Lower Canada.
I think in fact, he seemed to be proposing this for all the annuities, although it's not clear in the transcript that Casalt for Quebec seemed to suggest that because annuities reflected a future payment at a time when only one province would have possession of those lands, that it would make sense to regard them not as debt to be divided between Ontario and Quebec, but rather as a Section 109 trust. The thinking being, I suppose, that they were in effect a charge upon the land, I think was his argument. That argument didn't prevail, and I think in light of the fact that they opted to divide them as debt, it shows that Cameron's view prevailed, I think.
It might be helpful just to go back to slide 150 and 151 really is where you summarize the views of Quebec's council.
Okay, yes.
Can you just And I think you've essentially done the same
Um,
for Justice Hennessy now, but maybe we could look at slides 150 and 151 to see, that's a good summary, I think, of Quebec's.
Yes,
council's
please, if we
position.
can get slide 150 up, that would be good. Yeah, so I say on slide 150, Quebec's council during the section 142 arbitration viewed Indian annuity obligations as a trust. In a December 1869 memorandum submitted on behalf of Quebec before the section 142 arbitrators ruling, Cassault and Ritchie for Quebec observed with respect to Indian annuities that by section 109 of the BNA Act, and I'll quote them here, all lands are made over to the province within which they're situated, subject, however, to any trust existing in respect thereof, and to any interest other than that of the province in the same. The lands, being within the province of Ontario, became under section 109, the property of that province, subject, however, to the interest of the Indians on the same. This interest is the payment of the annuities stipulated as a compensation for the lands ceded.
And then on slide 151.
They, being Quebec's council, added that it might also be called a trust, the administration of which is left to the Dominion, the legal guardians of the Indians. Ontario, receiving the lands and the arrears due for those sold, is subject to all legal and equitable claims which may exist on them. It should therefore be charged with the principle of annuities. It would be manifestly unjust to require Quebec to share in paying for these lands, which will be the effect of the capital being allowed to remain in the statement of liabilities, unless compensation is required from Ontario from the lands and arrears representing the capital of these annuities.
Can I ask then, when he talks about it would be unjust to require Quebec to share if, which would be the effect of the capital being allowed to remain in the statement of liabilities. What statement of liabilities is he talking about here?
I think he's talking about the pool of debt to be divided. That if
Of
it,
the-
oh, sorry, the excess debt to be
Of
divided
Which
between.
entity of the
um,
Quebec, Ontario, Dominion, what
I'm
province of
sorry,
Canada?
the debt of the province of
Thank you.
Canada, yes.